You are watching Germantown Municipal Television, your source for everything Germantown.
Hello and welcome to Law Talk on Germantown Municipal Television. My name is Vince Perryman and I'm a local attorney with the law offices of J. Vincent Perryman. Each month, Law Talk focuses on a wide range of legal issues and topics. Today's show covers elder law. With us now is attorney Bill Jones of the Jones Law Firm. Bill, thanks for being with us today, and I guess we're doing a little bit different here where I'm the expert. Well, I can't say expert because the...
Well, you know more than I do.
Right.
Because if you're going to interview me about elder law, it's going to be a real short interview.
That's right.
I know zero about the topic. But you've been on this program for so long, and folks have always seen you interviewing people, so we thought that it might be nice for a change for them to know that you are a practicing attorney, and that you've got a very wide focus and knowledge on elder law. And it's just a topic that everybody needs. So I thought maybe today would be a great opportunity for you to enlighten us on what it is that you do instead of the other way around. So tell us a little bit about what your practice generally entails. What is elder law?
Well, with elder law, generally it's got three broad parts of it. One is the estate planning component, which also deals with estate administration and also tax issues that may arise with that. Then the second component of elder law is the Medicaid, disability, and other long-term care issues. And then the final one is guardians and conservatorships and commitment matters, which would include the fiduciary administration of a guardianship or a conservatorship. So
let's start out with your first topic. Your first topic, the first component you said was basically estate planning. So when I think of that, I just think of a will.
Right.
So tell me kind of what goes into that, who needs it, when should we need it?
Well, and with this, when we're talking about elder law, we're talking about you're in an advanced age, depending on what you think advanced age is. Generally, we're talking about somebody that's near retirement or past retirement age. So someone that is that age, they're going to hopefully have had substantial assets built up, which means they're going to need more provisions in their will than the average, newly married couple that comes in with a couple of kids, things like that. So when we're talking about a will, the basics of it would be you need to know what you've got, who you want to make responsible to see that your wishes are carried out, and then who you want to receive it. Now that's a pretty simple document, but with adult children, you may be dealing with the never-do-well spouse that one of them is married that you don't want one of your children to deal with, so you'd have to have certain drafting to draft around that. You may be dealing with grandchildren or great-grandchildren in there that you want to provide for. Some of those may have special needs, so we have to devise the gifting to them in your testamentary document in such a way that doesn't affect the other government assistance that they might get. And then, you may have a child or a beneficiary who just has issues and you need to put what they are going to receive in a trust so they don't just blow it or their creditors get it.
So you're talking about maybe later on in life, if I think one of my children is just going to be a spendthrift, that they're just going to blow through the money, there are some things that you can do in that document to kind of put the handcuffs on them for a little while?
Yeah, you can put together testamentary trusts that say, I always talk about it, what a testamentary trust is going to do is it locks the assets away in a room, and you put a provision in there that says, beneficiary of mine or child of mine, if you reach a certain age and have a bachelor degree or something like that, those are the keys to the door that lets the money out of that room and into that child's pocket. Okay.
So we've talked about creating the original documents, and that's, I guess, the planning stage. I think next you said the next component would be the administration. Now, when my wife and I did wills with you, we just set it up where she was my administrator and I was her administrator, but I assume that's because we're both young. In an elder baby boomer kind of situation, what's the administrator going to do?
Well, the administrator is either going to oversee the assets as they go through a probate, which is a court transaction, or if they created a living revocable trust, then they're going to serve in a fiduciary capacity as the trustee of that trust and manage the assets there outside of the oversight of probate court.
All right, so you used a term there, and I know what it means, but let's cover it real quick. You said that this person would be in a fiduciary capacity. I know that comes a little bit later, but let's go ahead and touch on it now. What this administrator, this person, what is this fiduciary duty that they would have?
Well,
and what is a fiduciary duty?
What the fiduciary duty is this, that they owe a duty to take care of the assets that are in the probate estate for the beneficiaries and make sure that they go to the beneficiaries. And they're also, in the probate, they've got other creditors that they owe a duty to, such as you got to give notice to TennCare, notice to all of the beneficiaries under the will. Any known creditors, you've got to give them knowledge with that. At the start of the day and the end of the day, if something goes wrong in probate, they're held accountable for that. So normally they have a fiduciary bond with the company, so if something goes wrong, then the bonding company comes in and can pay out on that.
So this is the person that basically is going to open their arms, pull in everything that the estate had, and then, pursuant to whatever planning you've done, they're then going to send it back out according to the will after creditors have been paid?
That's correct.
Okay.
And then the other thing, though, is you might be a fiduciary under a trust. If you are, there's going to be certain duties that you have under the law to the beneficiaries of that trust. And we may draft in some specific duties under the trust document. But with the trust, it generally, none of that's going to be public knowledge.
Talk to me about, I know when my wife and I came to see you, we were generally worried because we had kids and we were going on a trip. But you're talking about an elder situation where there are substantial assets that we didn't have 10 years ago. What's the cutoff? Where should people start thinking about, and when do the tax implications change?
Well, you've got tax implications on that are continuously changing, but for all intents and purposes on the federal side of it, if you've got over $5 million of assets, that's when you've got to worry about the tax issue with it. Now, the other thing with it is if you are trying to, well, we've got to wrap up and we'll address this when we come back.
Okay.
When we return, we'll continue our discussion on elder law. Please stay with us.
I'm Germantown Mayor Mike Palazzolo.
And I'm Germantown Alderman Forrest Owens.
And we're here to pump you up. Germantown has been selected as a pilot in a new statewide initiative called Healthier Tennessee.
We invite you to join us and make Germantown a healthier place.
The first step towards success is simple.
You just download the app. It's called Streaks for Small Starts.
The app allows you to track the healthy choices you make every day, like drinking water, eating fruit, and getting exercise.
Might even get you on your bike.
You'll see the small steps you take every day add up to big changes over time. And you will be pumped up like us, or at least on your way to a healthier lifestyle.
Psst, they're coming. Places, everybody.
Light check. 1, 2, 1, 2.
Everything looks good on our end.
And lights.
Come alive with the forest. Visit discovertheforest.org to find a forest near you.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. I'm Vince Perryman. You're watching Law Talk. Joining us on our show is attorney Bill Jones from the Jones Law Firm, and we're discussing elder law.
Yeah, and I've got some great questions for you. I think before we hit the break, you and I were talking about it. What's the cutoff? What's the difference? You indicated that $5 million was for tax purposes. I'm talking about practically. If I wanted to set up a trust, how large should my estate be to make that economically advantageous?
Well, and that's what's kind of interesting with it. It's just like in business deals. You don't always want to have the economics driving it. There may be other reasons for it. So if somebody's an extremely private person, then they may want to do a trust so that way it doesn't go through probate, because probate is a public record out there. We can go down to probate right now, find out exactly what Elvis gave to who, and get a copy of his will. We can do the same thing probably with any of the other famous folks that came out of Shelby County. So privacy may be one reason on it. If you know you've got people that are going to inherit from you, or you're disinheriting, that are going to create a litigation risk for the other beneficiaries, you may very well want to do a trust there. And when you're in the category of elder law, you pretty much know which beneficiaries are a problem and which ones aren't. You know who's responsible, who's not. Because like when you guys come in to do a will, you and your wife, you got a little one, and you don't know whether he's going to be responsible or not.
My fingers are crossed. Yeah, I don't know, but yeah, you're right. He could go out, he could get the 18 earrings, the tattoos, and enjoy worshiping Satan on the weekends. In which case, I don't know what to do. And you're saying we put a trust in place.
Right. So the whole thing is that's when, you know, and that's the other thing about estate documents. They're fluid. Death and taxes are consistent. So every year on April 15th, when you're having to deal with the taxes, you might as well think about your death and say, is there anything that I did in my estate planning that I need to change as a beneficiary? Because when you're an elder, your beneficiaries may pass away, or who you have chosen to make the fiduciary under these may have passed before you.
So this is not something that we need to just create, put in a shelf, and forget about. It's something we need to revisit and make sure the provisions we've set up are still good.
Right.
So let's talk about some of those life-changing things that can happen. I know from personal experience, my grandmother had some of these things set up, but she didn't pass away quickly. She had a slow decline over about an 8-year period, and we had to look at some serious issues that you were talking about earlier, with like taxes, Medicare, TennCare. How does that figure out how do you plan for something like that?
Well, and there's a couple of
not passing, but planning for the end of life.
Well, some of it is your other estate planning documents outside of the will and the trust, making sure that you've got a durable power of attorney for health care and for financial. What that does is it gives somebody the ability to step into your shoes should you be incapacitated, to take care of those decisions for you. And the reason why it's important is that third segment of elder law with conservatorships and guardianships. The way the law is written, whoever is your power of attorney is given preference, or your next of kin, if somebody has to get a conservatorship over you, which if you have a power of attorney that is written correctly, there won't be a need for a conservatorship.
Now, I've always heard that you should be careful, and we've seen it, you and I have seen it in litigation, just giving out a power of attorney. So if I fill out a power of attorney to you, does that give you the right to do everything? Is it effective now? How does that operate?
It depends. So if you can say it's effective of whatever date that you want. If it's immediately effective, then I could go out and I could change things for you. That's probably not your intent. So what you want to do is to have something called a springing power in there, which says, should I be incapacitated and my doctor says that I'm incapacitated, then this goes into effect.
Okay, you mentioned doctor there. I was thinking about like a power of attorney that would allow me to go to MLG&W and say, hey, I want to pay grandma's bill. Would that same document allow me to go to a physician? I know there's a lot of HIPAA regulations, Would it allow me, or would I need a separate document to deal with the physicians?
Well, with the physicians, that's a durable power of attorney for health care.
Okay.
Okay, and the other thing that's always a unique thing in there, if you want something done specific with your remains, you need to include it in your durable power of attorney for health care, because the geniuses in Nashville decided that they would legislate and say whoever was your power of attorney for health care is the first decision maker as to your remains.
So you're talking about the difference between cremation or traditional burial, or whether or not we want to have a military funeral. Whoever is listed on your power of attorney for health care is the person that gets to make that decision.
That's right. And when I draft one, I've got a separate section in there that's inset, kind of saying to the funeral home, hey, take a look at me, so that way if they come in, they're aware of what the wishes are. You know, on some of these, I've drafted them where someone is cremated, half of their remains goes to Japan, where they were from, half of their remains go here, where they did business and lived. Others to be cremated and take one more ride down the Buffalo River. You know, a farmer wanted his casket to go around his farm one last time.
Do these things that we're talking about, do they tie in with the estate planning and with the will? For example, could you say, if Bob doesn't take me on the tractor around, then he doesn't get anything?
You could if you wanted to write somebody out like that, but generally what it is letting people know what the wishes are, because when you go to the funeral home now to make arrangements, they will ask if the decedent, that is the person that passed away, had a durable power of attorney for health care, and they'll ask to see it.
I know a lot of people, it's a good thing, and I know it deals with pre-tax dollars. You can pre-purchase your funeral plot and your estate planning, or not your estate planning, your burial at the funeral home. How does the family know that exists? Is that something that...
Well, and that's the thing, you know, anybody that I do estate planning for, I say, okay, here are your copies and here are your originals. You want to put your originals in a safe place to where, you know, generally that's going to be a safe deposit box at a bank so they don't burn up. A lot of people want to use those in-home safes, but the thing about it is now the ink that we use will evaporate if it gets to a certain heat, so it may not burn up, but it evaporates what was on the paper. And all of your copies and any of your wishes and stuff, you want to put those where somebody can find them. They're all in one spot, so that way they are aware of what your wishes are.
So these estate planning documents would make mention of the fact, I've prepaid for a funeral here, I want to be buried here.
Yeah.
Okay.
Yeah.
All right.
And well, and it's one of those things too, now in today's society, we've got several passwords for stuff and, you know, sort of an internet life. Sometimes we don't see that as much in elder law, but if it's there, that's something else you want to do is wherever your testamentary documents are kept, keep a list of your passwords and how to gain access to those accounts. So if there's something digital they need to get, then they can get to it. And now, when we return from our break, we'll talk more with Bill Jones about elder law. Please stay with us.
Really?
Buzz, what's up, man? You left some leaves burning out here.
Yeah, I just came in just for a second.
Come on, man. If it's too hot to touch, it's too hot to leave. You could torch the whole neighborhood.
It's a good point there, Smokey.
9 out of 10 wildfires are caused by humans.
Only you can prevent wildfires.
Everybody has a dream. Mine was to see the ocean. And with a little help, I made it.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. With us now is Bill Jones. We're talking about elder law.
So Vince, we've set up these documents. You've given me my copies of my will, my living will, my power of attorney, and my power of attorney for health care. What do I do with them then? I mean, let's say that I go out, I go running with the bulls in Pamplona, and they gore me, and I'm rushed to the med. How are they going to know that I've got a living will and a power of attorney?
Well, hopefully it's your general doctor and you've given them a copy of it, so that way they know that there's one in place. The other thing is, whoever your power of attorney is, you probably want to share a copy of that document with them, because there's a provision in there that says a copy's as good as the original. Now, sometimes they'll ask for the original, but if it's one of those that it also has prepared by, so if they've got questions, they can call me or whoever prepared it. But that way, you've got two different versions there. Now,
so it seems like the wise thing to do with this power of attorney for health care, if I'm sent over to a different hospital, to Methodist North or Methodist South or St. Francis or wherever, take a copy and ask them to add it to my file, so wherever I end up, they've got it on file. Is that something you'd recommend?
Yeah, that is.
Okay.
And some people go so far as to file it with the Registered Deeds Office, so that way it puts everybody on public notice. That can then avoid a situation where you have somebody that may be in a state of confusion or something of that nature, signing deeds or documents, devising their real estate to someone else.
What I have seen with my clients over my practice is that this is something that folks like to bury their head in the sand and put off as long as they can. They think that because they write a will, they're going to die the next day. And you and I know that's just not so. But what I see is the tragedy sometimes of somebody calling in and saying, I'm going to bring my mother in. She's in early stages of Alzheimer's. She doesn't know what year it is or who the president is. She thinks a bottle of Coke is $300. You want to sell her a six-pack, but you don't. What do you do there? When somebody comes in and this person is not competent to exercise or to sign a living will, to sign a power of attorney, do we just throw our hands up and say, okay, we'll just deal with it like we can?
Well, and that's what's interesting. Sometimes, like with somebody that's in Alzheimer's, they may be on a good day, they may know exactly what they're doing. If that's the case, you're working in a gray area there, which is probably going to lead to a malpractice claim after they pass away with the kid that didn't bring them in your office. So the situation with that is, it's simply that we can't revise these documents, we can't do new documents, but what we can do is we can go into the probate court and apply for a conservatorship, where we have an affidavit from the doctor that says, look, they do need someone to be a conservator over the person or a conservator over their finances, or possibly both.
So you're talking about basically taking away their rights to handle their own affairs. What's the burden there? I would assume somebody's got to be, how bad off would somebody have to be to take away their rights?
Well, it depends. First, the court's the only one that's going to be able to take away the rights. So there's going to be a court hearing. And the way that court hearing works is if someone is going to apply to be a conservatorship over conservator over that person, the person that you're over that a conservatorship is over is called a ward. Okay, so that the person that wants to be the potential conservator goes in, they've got an affidavit from a treating physician of the potential ward saying that yes, they do need this. So we've got a doctor's opinion on it, and the first thing that the court will do is appoint a guardian ad litem, which is another attorney who is specifically working for the court to determine what's what. They're going to go out, they're going to look at the medical records, they're going to talk to that doctor, they're going to talk to the potential ward, they're going to talk to the potential conservator, they're going to talk to any other relatives that are related to that potential ward, and they're going to put together a formal report and come back to the court with that. Now,
so it's not as simple as me saying, Dad, I think you're going to cut me out of the will. I'm going to take you to court, get power over you, then I've got the money and can cut my brothers out. I have got to go to court, have a doctor's opinion, and then an independent attorney say that he's...
That's right.
and then they're going to check how I'm handling the estate?
Oh, and there's a whole nother risk in there that we didn't quite cover. If that independent attorney that's appointed as guardian ad litem is talking to your father and your father says, this is just BS, I want my own attorney, the court will appoint him an ad litem, an attorney ad litem to represent him. So you can wind up in a situation with 3 attorneys in this case.
So this is something that really needs to be done when the party truly needs to be cared for, not as a way to control or manipulate.
Well, and the other thing is that's what's so important about the power of attorneys, because whoever you appointed as your power of attorney is going to get deference when they go into probate court should someone else go in there and deal with this. Now, if you're appointed as a conservator over a ward, then you're going to have to file an annual accounting and a property management plan with the court, and the court's going to approve the property management plan, which is going to say these are all the assets that the ward has, and this is how we're going to manage it. We're going to either sell his home, or he's going to live in his home. We're going to have skilled nursing. This is all the costs. It's really a difficult thing to manage, because sometimes you'll see where a child will be appointed as the conservator, and they're also going to be the primary caregiver for that parent, and they just mentally, it is difficult on them because you're having to do everything.
It seems to me that, like in what we're discussing, the catch-22 seems to be that this is something you can only handle when you're in your right mind, when you're young enough to go in and create these documents. And if you wait too long, you can't do that power of attorney to a point and give that person deference. So it's really something that folks need to get in and get taken care of when they can, not when the other shoe's about to drop.
Yeah, because the other thing to know about the conservatorship, if it goes through, all those attorneys get paid out of the ward's assets. So think about that for a second. If you got 3 attorneys and they're all being paid by the disabled party, that's a lot of money that could be going for their care that's going to get eaten up, whereas you wouldn't have had any need for that if you had it taken care of it on the front end with some simple documents.
So let's talk about taking care of it on the front end with some simple documents. Whether it's you or somebody else, what do they need?
Okay, and we've got to wrap up here, so there's 4 documents that they need. They need a will, a power of attorney for health care, a power of attorney for financial, and advance directives or a living will, which says pull the plug, don't pull the plug, that sort of things.
Gotcha.
If you've got those 4, you're in good shape. And you can have all the bells and whistles that adds on the rest of it. But that's it. So our time is up for this edition of Law Talk. I'd like to thank our guest for taking time out of his busy schedule and being with us and sharing his thoughts and insights. If you'd like more information about Law Talk or any other program on Germantown Municipal Television, please refer to our website at www.gmtvonline.org. Thank you for joining us today, and be sure to join us next month for more discussion on legal topics. Until then, I am Vince Perryman, and thank you for watching.